The date a lot of HR teams are not ready for is coming. Here's a situation happening right now across HR and legal teams in Europe. A compliance lead at a mid-sized tech company is preparing for the EU Pay Transparency Directive deadline. They go to their EOR to pull the headcount data they need for the report. And the EOR comes back and says, we can't give you the data cleanly. Your employees are technically employed by our local partner entity, not by us directly. The data lives on their systems. All this 3 weeks before a mandatory reporting deadline. This is data they legally need to produce and they can't access it. This is not an edge case. It's a structural problem built into how a large portion of the EOR market is constructed. And it's exactly the kind of thing that only becomes visible when something goes wrong. But it doesn't have to be that way. In this video, we're covering how hiring works across EMEA, the UK, Germany, France, and beyond. Why this region is the most compliance intensive in the world right now, and what to look for in an EOR before you sign. Here's a quick summary for anyone coming in fresh. An employer of record is a third-party company that legally employs workers on your behalf in countries where you don't have your own legal entity. You direct the work. The EOR handles contracts, payroll, tax, benefits, and compliance with local employment law. In EMEA, this matters more than almost anywhere else in the world for one simple reason. Employment law across the region is extraordinarily employee protective, highly jurisdiction specific, and actively enforced. The EU alone has 27 member states, each with its own implementation of EU directives layered on top of their own domestic labor law. The UK has diverged from EU standards post-Brexit and is developing its own framework. South Africa and Kenya operate under entirely different statutory systems again. Getting any of this wrong isn't just an administrative inconvenience, it's financial liability, reputational risk, and in some markets, criminal exposure for the employing entity. An EOR removes that risk, but only if it's built to handle it. Let's go country by country. The UK is the first port of call for most companies expanding into Europe. English-speaking, strong talent market, familiar legal system, and post-Brexit, it operates entirely outside of EU employment law, which is both a simplification and a complication, depending on where you're coming from. Here are key things companies get wrong when hiring in the UK. IR35 and worker classification. The UK has some of the strictest rules in the world around contractor versus employee classification. IR35 legislation means that if someone is working for you in a way that looks like employment, fixed hours, direction, control, integration into your team, HMRC can reclassify them as an employee with backdated tax and national insurance liability falling on you. Many companies discover this years in when the bill arrives. UK employees are entitled to a minimum of 28 days paid annual leave. This includes bank holidays. They've got statutory sick pay and auto-enrollment into workplace pension schemes. These are non-negotiable baselines. Now, termination. UK employment law provides strong, unfair dismissal protections after 2 years of continuous employment. Redundancy processes have statutory requirements around consultation periods, notice, and severance pay. Getting this wrong, particularly around process, is one of the most litigated areas of UK employment law. National living wage. The UK uprates this annually. An EOR needs to track and apply this automatically, not manually. Germany is where companies consistently underestimate compliance complexity. The German labor market is heavily regulated with strong trade union influence, robust works council rights, and statutory protections that sit well above EU minimums. Work councils. If you have 5 or more employees in Germany, they have the right to establish a works council. And what are those? Works councils have co-determination rights, meaning they have a formal say in decisions around working hours, performance management, and even some hiring decisions. This is not optional and cannot be contracted away. Now, termination. Germany has a Dismissal Protection Act, which applies from 6 months of employment. After that point, termination requires documented, socially justified grounds. It has to have performance-related dismissals in particular, which require a lengthy, documented process. Getting this wrong results in reinstatement orders or significant settlement costs. Notice periods. Statutory notice periods in Germany scale with length of service up to 7 months for long-tenured employees. These are minimums. Contracts can extend these even further. Social Security contributions. German payroll involves mandatory contributions to health insurance, pension, unemployment insurance, and long-term care insurance, split roughly 50-50 between employer and employee. The employer burden adds approximately 20 to 22% on top of gross salary. An EOR without genuine in-country expertise in Germany will struggle to navigate Works Council obligations and termination processes accurately. France sits alongside Germany as one of the most complex employment markets in Europe, with a few distinctly French complications. The collective bargaining agreements, for example. France has over 700 sector-specific collective agreements, and they're not optional. If your employee's role falls under a particular CBA, which is determined by the company's activity sector, not by choice, the terms of that agreement apply on top of statutory law. These set minimum salaries by role grade, specific holiday entitlements, and notice periods that can exceed statutory minimums significantly. The 35-hour working week. France's legal working week is 35 hours. Hours beyond this are overtime, and they are subject to premium pay or time off in lieu, depending on the applicable CBA. Managing this correctly requires payroll infrastructure that tracks hours accurately and applies the right rules automatically. Profit sharing and incentive schemes. Companies with 50 or more employees in France are required to implement a profit sharing scheme. Below that threshold, it's optional but common. An EOR needs to factor this into cost modeling. Now, termination. French employment law has a mandatory conciliation process before dismissal with specific procedural steps. Skipping any of these steps creates grounds for the dismissal to be ruled unfair, regardless of the underlying reason. Those were pretty intensive. Now let's do a rapid-fire breakdown of the other key markets in this region. Take Ireland. It's the European headquarters for a large number of US tech companies, which makes it a common first hire for EMEA expansion. Employment law is EU aligned, but with Irish-specific rules on statutory redundancy, public holidays, and the obligation to provide employees with a written statement of terms within 5 days of starting. The Netherlands has strong employee protections, particularly around the distinction between permanent contracts and fixed-term contracts. Dutch law limits how many times you can renew a fixed-term contract before it automatically converts to permanent. The 30% ruling, a tax benefit for highly skilled migrants. This is also something talent ops teams need to factor into compensation packages when relocating international employees. Spain operates under a system of collective agreements similar to France, with sector-specific terms that override statutory minimums. Spain also has one of the more complex severance structures in Europe. Employees dismissed for objective reasons are entitled to 20 days' salary per year of service, capped at 12 months. Portugal. It has seen a huge increase in international hiring interest, particularly from tech companies. Employment law includes strong anti-dismissal protections and mandatory notice periods. Portugal's non-habitual resident tax regime, recently reformed, is still relevant for attracting international talent. Now, how about Malta? It's a small market, but relevant for companies operating in financial services and iGaming. Maltese employment law is EU-aligned with specific rules around part-time workers and fixed-term contracts. Now, Latvia. It's one of the lower-cost talent markets in the EU, with a growing tech sector. EU employment law applies, with Latvian-specific rules on statutory leave and social security contributions. Now onto two markets worth covering in detail because interest has grown significantly and the compliance picture is genuinely distinct. South Africa has a sophisticated labor market governed by the Labor Relations Act, the Basic Conditions of Employment Act, and the Employment Equity Act. The Employment Equity Act introduces specific obligations around diversity reporting and employment equity plans for companies above a certain size threshold. Obligations that are not common in other markets and catch international employers off guard. Termination in South Africa is highly procedural. Dismissal requires a fair process, typically including a disciplinary hearing. Skipping the process, even when the reason for dismissal is valid, results in the dismissal being ruled procedurally unfair, with compensation orders following. Now, Kenya. Kenya is the anchor market for East Africa expansion with a growing tech and commercial talent base, particularly in Nairobi. Employment is governed by the Employment Act, with statutory entitlements including 21 days of annual leave, maternity leave of 3 months, and mandatory NSSF and NHIF contributions. Kenya's statutory deduction system is less complex than South Africa's, but requires accurate payroll infrastructure to manage correctly, particularly around PAYE calculations. This is the most immediate issue for any company with employees in the EU right now. The EU Pay Transparency Directive requires companies to report on pay gaps, provides salary information to job candidates, and gives employees the right to request pay comparison data. Member states have until June 7th, 2026 to transpose it into national law. The headline obligation is clear enough. But there's a technical trap buried in how EOR employment structures work, and a significant number of companies are discovering it too late. Here's the problem. If your EOR uses a pooled entity model where your EU employees are technically employed by a local partner firm rather than by the EOR directly, those employees may be counted as employees of the partner entity, not of your company. That has two consequences. First, it means your headcount thresholds may be triggered earlier than you expect. The directive's most stringent reporting requirements kick in at 100 employees. If the EOR's partner entity employs workers across multiple clients, all of those workers may count towards that threshold, meaning you're in scope for obligations you didn't anticipate. Second, and more practically, it means you may not have clean access to your own compensation data. The data lives on the partner system. Getting a structured, compliant report out of it is not so straightforward. Companies using an owned entity EOR model don't have this problem. The EOR owns the entity, the employment relationship is clean, and the headcount data is yours to access on demand. If you haven't already, ask your EOR directly, are my employees employed by your entity or by a third-party partner? And can I pull a complete structured headcount report right now? The answer will tell you a lot about what June 7th looks like for your team. Now, building on the general EOR evaluation framework, here are the EMEA-specific questions that matter most. Do you own your entity in this specific country? Not, do you operate in this country? That can mean partner arrangements. Ask specifically whether they own the legal entity. For Germany, France, and the UK in particular, this is the question that separates genuine infrastructure from a reseller arrangement. How do you handle Works Council obligations in Germany? If the answer is vague, that's a signal. Works Council co-determination rights require proactive engagement, not reactive compliance. An EOR that doesn't have a clear process here will create problems at scale. How do you apply collective bargaining agreements in France and Spain? CBA compliance requires knowing which agreement applies to each role and applying it automatically. Ask how they determine the applicable CBA and how that flows into payroll. Can I access my full EU headcount data for pay transparency reporting? Ask for a demo of this. Not a description, an actual demonstration of what the report looks like and how long it takes to generate. You'll come back and thank me in the comments. So this brings us to our last question. Why choose Multiplier? Here are 3 reasons why our infrastructure is built for EMEA. Multiplier owns its legal entities in the markets it operates in. No partner dependencies, no data handoffs, no liability ambiguity. When you hire through Multiplier in Germany or France or the UK, the employment relationship is clean. Compliance obligation sits with Multiplier's entity, not with a third party. Compliance is baked into the platform. German Works Council rule, French CBA applications, UK IR35 safeguards, EU Pay Transparency reporting. These aren't manual processes managed by a local partner. They're built into the platform's compliance engine, and it's updated continuously as laws change. Pay transparency ready. If your company needs to produce EU Pay Transparency reports, Multiplier gives you structured headcount and compensation data on demand. No chasing partners, no data gaps, no 3-week extraction process. We've got you. Check it out. You can book a demo. It's linked below. But that's not all. We're going global. Our world has no limits, so why should your EOR? Subscribe to see what's coming next.